Good morning, everyone. Thanks for joining us, and welcome to the Center for Canadian Innovation and Competitiveness webinar on the Artificial Intelligence Act, otherwise known as AIDA. I'm Lawrence Zhang. I'm the head of policy here at the center. Artificial intelligence regulation has been a very hot topic around the world in the last few years, and Canada has not shied away from joining in. More than 2 years ago now, the Minister of Innovation, Science and Industry tabled AIDA as a part of Bill C-27, the Digital Charter Implementation Act, with much ado about the risks and harms of artificial intelligence that's posed to Canadians. As the bill's been making its way through committee, critique of AIDA has arisen from all sides. Today, I'd like to focus on what the impacts will be on Canada's AI ecosystem, for the startups developing AI technologies, for the researchers that are building the next generation of AI models, and businesses that are implementing AI systems to become more productive. I'm joined today by Malika Carroll, the head of Global Government Affairs and Public Policy at Cohere, Michael Facchetti, partner at Osler, Hoskin, and Harcourt LLP's Technology Group, and Colin McKay, head of Canadian Policy and Public Relations at Wabi. And before we begin, I'd be remiss if I didn't mention that this is an interactive conversation. So you, the audience, are strongly encouraged to ask us questions in the Slido. You can find the link on the webpage description, or if you're watching via YouTube, you can find it there. So as I mentioned, AIDA was introduced 2 years ago with a great deal of urgency, with the government expressing serious concern that Canadians would be subject to harmful or discriminatory outcomes because of AI. A lot of critique has been sort of hand waved away with the retort that, yeah, it's important that we get the legislation in the books first. Any issues can be sorted out in the regulations later, and don't worry about it for now. Yet, in the 2 years that the legislation has been in Parliament, there have not been any major incidents that have proved this cause for concern. In light of this, the government may have some opportunity now to perhaps take a step back and reevaluate whether it wants to get it right or whether it wants to get it right now. Knowing what we know now, what are some areas that AIDA got right and what did it get wrong? Michael, why don't we start with you?
Well, thanks, Lawrence. And I want to just thank you for the opportunity to join this discussion today. I believe the discussion of artificial intelligence regulation is so critically important. It's so important that we get it right. It's important for productivity enhancement in Canada. It's incredibly important for economic growth in Canada, the AI ecosystem. And really, that's a good segue into what I would like to say they may not have gotten right, and that is the sense of urgency. There was no time to consult, or there were certainly no consultations before AIDA was introduced, and there was no international consensus on what AI regulation should look like. You know, we can question whether or not the existing laws that we do have on the books are working to prevent the types of harms that are relevant in the near term, like misinformation, like bias, and really ask whether or not the focus should be on frontier systems, on the most advanced systems that create more of what I might call the existential risks that we hear some AI developers talk about. So, you know, you can't ensure interoperability if you're first out of the gate. You really may not get it right, and that's perhaps where we are right now. Now, in terms of what they got right, I think there was a recognition in the outset that you need an incremental approach. You need to have an initial baseline with the ability to add to the scope of regulation and perhaps adjust requirements through regulatory changes and through the adoption of rules or regulations through the framework that we have here in Canada. And I think that is an important positive in terms of what the government has tried to identify as their solution.
Malika, do you have any thoughts?
Sure. Maybe to take a bigger step back on what the government got right. I think it's important to remind everybody here that, the Canadian government launched a pan-Canadian AI strategy in 2017. And that was a lot of foresight, and that was very successful, right? It's made Canada a global hotspot for leading talent and research. And I think sort of thinking about continuing to get it right, it's important that the legislative framework foster that environment, continues that, and keeps Canada at the forefront of AI. And that's important sort of context for where we want to go going forward. And I think, so Cohere, we sell models to enterprise and public sector customers. And those customers have the highest standards and demands for safety, trust, reliability. They want the state-of-the-art models, so they want innovation. They want technology they can trust. They want it to be safe, secure, private, and they want to do everyday things, not catastrophic risk type things. And so what we're looking for and what we think needs to kind of be fine-tuned, if you will, no pun intended, going forward with the legislation, is getting that balance right between innovation, safety, and mitigating risk. And so we support legislation, and we think it's important to have it to give trust and safe sort of certainty in this environment. But maybe just to dig into what and add to what Michael was saying on what we can do better, is I think to be a little bit more sort of tactical, there's an opportunity here to clarify and sort of weave in the concept of proportionality throughout, making sure that the requirements and the obligations are proportional to the risks of each specific circumstance, right? That's an important, I think, concept we can continue to work on and improve in the bill. Another thing is just clarifying some of the definitions. As Michael mentioned, there's been some advancements in other countries as well. Global interoperability is important. Getting those definitions aligned to the extent it's possible across different jurisdictions is super important. And then finally, maybe one last sort of big bucket item is clarifying obligations between developers and deployers. An important point for us is when we deploy our models, and when our customers, more importantly, deploy our models, they do that in a virtual private network or on premise. We don't see what they do with it. So the roles and responsibilities and clarifying those obligations is really important, and we think that could use some more clarification in legislation.
Good points. Colin, what they get right, what they get wrong?
Thanks very much, Lawrence, and thanks to my colleagues for starting off. From Wabi's perspective, we come at this as both a company that's pursuing and has completed the development of a foundation model, but it's also integrating that work into our own products and packages for deployment in the physical world. And it's a very specific use case that's focused on an industry with potential for many, many other use cases in the future. And this seems to be the example that is missing from how AIDA is constructed. Because at its basic assessment, we are working in an area that relies on confidence in our product to deliver safety on the road and safety with drivers, as well as safety of our foundation model and its implementation in Wabi World and Wabi Driver, which means that we already have a regulatory infrastructure in place that supervises that absolutely essential safety regime and the assumptions Canadians and people around the world have about the interaction with technology in the physical world, whether it's a truck that's being operated by an individual or a truck that's being operated by a highly advanced software platform and testing platform. And in the way that the bill is constructed, there's an awful lot of confidence put into the regulatory work to come. And even basic distinctions between high risk and high impact, or the interpretation of the application of machine learning rather than general purpose AI within a product, makes assumptions about both the responsibility and the liability of the developer and the deployment, which in the case of Canada, as Malika highlighted, we not only have 7 years of history with the Pan-Canadian AI strategy, we have 30 years of history with fundamental investment in the basics of computer science and machine learning that's led us to the place we are now. And we have the incredible advantage that we have a number of companies across sectors, as well as in general purpose large language models, that are technology leaders and market leaders around the world. And the opportunity for Canada to set the standard and to set leadership within both these technological segments, but also completely new markets like autonomous trucking, relies on the ability to both understand the regulatory framework at home and its interpretation and application in other jurisdictions, whether it's the European Union or the United States or in Asia, and then being able to map out a commercial path that acknowledges and accounts for those risks and the benefits. And then that feeds into the business decisions we make here in Canada. And the reality is that we have had 2 years of ambiguity around a framework legislation that, while built on good intentions and an overall understanding of the implications of general purpose AI for society, it has very specific relevance and consequences as you drill into sectors and as you drill into new industries. And the challenge here isn't to create regulatory frameworks that define, codify, and then guarantee safety within those industries and sectors. It's trying to arrive at a model that allows for innovation and experimentation, and then full deployment with the confidence that participants in either the technology development or the product development understand, reflect, and are integrating Canadians' concerns into the technology. And unfortunately, we've had 2 years of debate about the legislation, and we're looking at another 2 years of debate about the regulations, while we have other jurisdictions moving forward with comprehensive frameworks.
So Malika, you mentioned the Pan-Canadian AI strategy. So let's say big picture, if we were to start from scratch, how can the government ensure to focus on the on the adoption part of responsible adoption rather than just really hammering the responsible part? Because at the end of the day, AIDA is created to ensure that Canadian companies can adopt AI responsibly and make sure that that it's used broadly. But then it's really focused kind of more so now on making sure that people can't really do everything they want to be able to do with it. So if we were to take a step back and say, let's start from scratch, let's do over. What do you think AI regulation should look like? Should it be broad horizontal legislation? Should it be more vertical? What should it look like?
Well, I mean, I think it's hard to imagine a scenario, and as Colin was mentioning, it's hard to imagine a scenario where sectoral regulators are going to sit out on the sidelines, right? They have domain expertise, and like they have for a range of other technologies like cloud computing, they're going to likely issue and have, in some cases, have started issuing already their own guidelines and regulations for adoption of AI in different sectors like public sector, financial services, et cetera. So while there might be some benefits to a horizontal approach, I think thinking about that approach as being clear enough and consistent enough to also enable what's inevitably going to happen in a sectoral sense, I think is a really important. I don't know if Michael or Colin have anything to add to that.
Colin, this must be a lot of relevance to you guys. I don't imagine Transport Canada is going to sit by and kind of twiddle their thumbs when we're talking about AI regulation on self-driving cars.
No, as a matter of fact, they're currently running a consultation on the regulation of enhanced technologies. And I'll reflect that the Department of Innovation does have the expertise in digital policy and has had the expertise along with its portfolio partners on artificial intelligence development and deployment and adoption. And the other departments that work in the physical world have regulatory mechanisms that haven't been moving at the same pace. So there is a disconnect there, and the disconnect needs to be addressed and reconciled so that implementation in the real world, whether it's medical devices or whether it's on-road devices or whether it's devices used in rural and remote areas, all approach the same principles, the same guidelines, and the same obligations. So I'm acknowledging that there's a pressure upon more traditional regulatory bodies. They recognize that, though, and they're thoroughly invested in understanding, researching, and then regulating the space within which they have responsibility.
Michael?
I think it's really important to go back to first principles. So if we're thinking about creating a regulatory regime to cover a new technology that has uses across society, beneficial uses, productivity enhancing uses that will help us solve some of the critical problems that we're facing in the world today, we should be very careful only to regulate as much as necessary to address identified risks. The decision we will have to make is whether we need to regulate the technology or regulate specific uses of the technology, specific harm resulting from technology. And of course, we should be focusing on harm, in my view. If we go too broad with regulation, we'll undercut innovation, we'll undercut economic development, we'll undercut our efforts to improve Canada's productivity performance. Focusing on harm allows us to really go at the risk that is acknowledged. It's important to recognize the risk, but not go further than necessary. The other principles I think that are critical are as Malika said, to focus on proportionality. So requirements should be carefully developed to think about implications and only go so far as necessary to ensure that the regulatory requirement matches the harm or the risk that's being addressed. And that's really another way of saying ensuring proportionality. Ensuring interoperability is key because we live and work in a global economy, and to look at the Europeans as adopting their approach, their regulatory model first, you say, well, the EU likes to regulate first. They like to believe there's what we refer to generally as the Brussels effect, such a large market that the global economy needs to take note of what's happening in Europe and conform with European requirements, and that can serve as a model then for the rest of the world. There is no such thing, to my knowledge, of the Ottawa effect. And so our urgency to be at the forefront of regulation comes with the risk of being out of step with what's happening elsewhere. And I think that's what's been borne out over the last 2 years. And then, my last principle would be to avoid double regulation or double regulators, right? And Colin's example is a great one, where we have Transport Canada as the subject matter expert, the responsible regulator for automobile safety. There is lots of discussion and work with counterparts in the US and other markets to ensure that the rules we have in the books today make good sense so that we have a global auto market. We don't have just unique rules that don't align with rules elsewhere without a good, very carefully thought through explanation anyways. And if we have generally applicable AI legislation that would cover companies like Wabi working in the auto sector, developing tremendously innovative solutions for the future, and we also have Transport Canada regulating, then we have a double regulator situation, if not double regulation. And so I think all these 5 principles that I've identified are critical to think about as we conceive of what ideal regulatory approaches to AI would look like.
Can I add to what Michael just said?
Of course.
Which is, there's also an important distinction to avoid the habit of piling on regulators and compliance infrastructure, which is something that Canada seems to be fond to construct, which is, as you look at the application of machine learning and generative AI models in a complex context, like in the physical world, you end up having to both explain and then interpret the application and the resulting implications of that implementation to both general purpose regulators within, as envisioned, the data commissioner, as well as the actual functional specialized regulators that understand the interaction between complex systems, sensor systems, and individuals and humans on the road in built infrastructure. And I've had the good fortune to work on AI policy for a very long time. And it's always been very difficult to communicate just simply the process of developing and implementing AI within a consumer product that solely exists online or exists within a data center and its implementation within a business process. Once you start trying to establish that foundational understanding of the technology, and then be working with someone who understands its implications for the framework for which they're responsible for regulating, it's a much more complex conversation. And that means that any implementation of artificial intelligence legislation, if it doesn't account for use cases, and as Michael was saying, doesn't have an appropriate definition of harm and what we're intending to regulate on a national general basis, means that companies like Wabi, who have a very focused approach to dedicating resources to these debates and prefer to reserve our resources for our actual safety regime and our deployment of safe tools, will have to put more time into working with those dual regulators or multiple regulators. And, I've also had the fortune of working with some very, very inspired individuals that work in policy in these related areas, who spend a lot of time understanding these nuances from a general purpose as well as a specialized perspective. And even the conversations we have we're both reflecting that with our extensive experience and our in-depth study and our continuing awareness of the development of this technology, we will identify challenges and identify opportunities even in our conversation. And that points to another problem with trying to have an overly broad regulatory framework, which is the core workforce and skill set for doing this work rests with computer scientists. And then interpreting it for a compliance regime or a regulatory regime, or translating it into broad social and political goals within the context of regulatory regime as loosely defined as AIDA, means that there's going to be a shortage of individuals that can do this work for the short term. That will change. It has been changing over the years. But what I'm pointing to is, even beyond the debate about the bolts and nuts and bolts of the regulatory framework, who's going to be doing the interpretation, who's going to be doing the assessment, and then who's going to be making the assessment appropriate and informed to the application of the technology, focusing again on industrial, role-specific, context-specific application of artificial intelligence in a modern world.
That's a great point, and it brings me to sort of my next question is, why don't we talk a little bit about the impacts that AIDA as is can potentially have on the AI ecosystem? You'd mentioned AI companies, and Wabi comes from sort of a rich history of AI research. So what impact will this have on AI research done in Canada? And Michael, you must be able to speak to companies that are adopting AI. How will this affect them, and what will this mean for them? Or Malika, what does this mean for Cohere in terms of implementing AIDA if it goes through as is? What does that mean? Do you have to divert additional resources, or what does compliance look like? So why don't we start with Malika, and we'll go around the table.
Sure. I think we're all investing resources already, right, to develop responsible and safe models, and are willing to dig into that and to continue to invest resources in that. But to Colin's point, there's a limited number of resources, and we have to make sure that we're balancing, right, the innovation, the product development, and these investments for compliance. I think one thing to keep in mind on the impacts is, we have Canada is a small market globally, and so if this becomes too burdensome, some companies can choose to avoid this market and not comply. But those of us who are established in Canada and growing here have to comply and have to make sure that we're following these rules. And so it's important that it not be overly burdensome for Canadian companies versus the rest of the world who are looking to deploy these models. I guess that's one kind of high level point. The other is there's a range of things that I think we all highlighted would be helpful to clarify. And on the cost side, one example of this, or the sort of burdensome nature of some of these requirements, is there's a proposal in the legislation to be super tactical, right? Of every time you change the model, there has to be a third-party audit at some level. The challenges with that, a model changes all the time. What's the trigger for the audit? Audits are expensive. What kind of audit? Who's going to do the audit? Where's the expertise for the audit? There's a lot of things that need to be worked out or simplified. And again, do we want to do this if the changes to the models are not causing any additional harm or risk, right? If it's just a regular change to improve the model? So there's just a lot of work that can be done to make the compliance with the legislation more effective, I think. And I think also, from a startup perspective, our investors are also looking at this and I think can have concerns about whether it's going to be, there's going to be a unique regulatory environment for Canada to build, to innovate, and to deploy the models. And I think that's an important thing to keep in mind as well. But hand it over to Colin and Michael to add here.
Michael.
And if you want to go first, Michael.
I'm happy to go next. What I think, and I'm going to cover adoption specifically. Malika and Colin, you're very well placed to cover the impact on companies working in the sector. But in terms of adoption, I think it helps bring a focus on the question of scope. With AIDA, we're purporting to regulate the technology broadly. All general purpose systems are regulated. The use cases that are used to identify high impact systems are very broad in general. They aren't tied to specific harm. There isn't a harm threshold within a use case. If you're in the use case, you're caught. And this creates real challenges for industry looking to adopt AI. I mean, first, there's just a ton of uncertainty right now. What will the regulatory environment look like? Should I wait until that's settled before making investments? Secondly, well, what will be the impact on technology that's made available to organizations? Will some providers of AI solutions from outside of Canada say, look, it's just not worth selling into Canada. The market's too small. The regulatory requirements too great. Better to focus on larger markets where I don't have the same requirements. Then there's the questions of, well, how does the regime that set out in AIDA potentially impact on users of technology? And that concept, the concept user, is not found in the legislation. The regulated activity is making available an AI system or managing the operation of the system. But there's lots of use cases where the most beneficial deployments of AI systems will require fine-tuning general purpose models. And I'll just use a law firm as an example. It's an industry I'm, of course, familiar with. If we were to take a general purpose model and fine-tune it with all types of prior deal data, contractual clauses, provisions that we've used previously, and really come up with a general purpose AI model that is fine-tuned to our business so we can more productively deliver our services to our clients, not a particularly high-risk use case. I don't really see how a business law firm is going to create any real risk harm in that front. But we would potentially be the entity that's responsible for managing the operation of this general purpose system. And if that's the case, then we have to be responsible for complying with the long list of assessments and testing, including third-party assessments that apply to anyone who manages the operation of a general purpose system. Now, that creates a real disincentive for industry, including law firms, to fine-tune general purpose models. And this is the risk of a broad regulatory approach. That was probably never within anybody's contemplation, a law firm fine-tuning a general purpose model to enhance its business and compete in a global marketplace for legal services in a manner which really creates no risk. But we're covered. And I don't know if that is the right outcome. I would suggest it's not. And again, it highlights why scope matters so much and why a more targeted approach to regulation, I think, is the better way to go, because you regulate only as much as necessary, focusing on harm, proportionality, interoperability, et cetera.
Lawrence, if I may jump in just to add to Michael's example, in this case, with this requirement for managing operations and who falls under that bucket or definition, Michael explained clearly why it's difficult for a law firm to then have to fulfill all the obligations in the bill if they are managing operations. In our case, it's also hard for us to do if we were, Michael's model provider, because we don't see what they're doing with the model. Once we ship it to them, in most cases, we don't have access to it anymore. That's why companies trust it. It's private, it's secure, it's on site in some cases. And so, it just to highlight the dichotomy there, the challenge with the broad nature, the sort of definitions that need some more work.
In Wabi's case, we've both developed the model, but are also training it, refining it, deploying it, and then refining it and redeploying it on a very frequent basis. It somewhat falls outside the scope of what the Act is imagining, because it's a very focused application of our model. But I will say that it equally is a question within the company. what do the developments in AI policy in Canada mean for the foundational research and development that the students that come to us as co-op students or as researchers, what work will they be doing and what research paths will they be setting, and can they accomplish that work within the environment of the foreseen Canadian regulatory framework? From the practical application of our technology within the built world, there's actually a very useful example, which is, as I mentioned, the regulators around road safety and motor carrier safety have to take on this technology, understand its implications. And there's been an active discussion for at least 10 years with regulatory frameworks in the states around what is necessary to implement autonomous vehicles and autonomous trucks, and what is the dialogue and then the reassurances that those regulators must receive. And it's constantly evolving, but it's a reflection of the recognition in those jurisdictions that they decided we're going to embrace innovation and we're going to embrace experimentation, and then build a lengthy and continuing relationship with those firms and those developers to understand the implications and the applications. It means, sorry, there's my cat. I was trying to keep him from doing that. There we go. Get down, buddy. People probably saw my hand go like this. That means that we now currently operate our autonomous trucks in the United States, as do all of our competitors, because the regulatory framework for operating on the road exists in the United States, and it doesn't exist in many other jurisdictions. And that's part of the decision making when you look at, are we developing something that's truly innovative and transformational, and can we do that in Canada? And what will be the engagement and then compliance process for both just simple information, but also feedback again with regulatory processes for technology like Wobbies and other industries.
So shifting gears a little bit, we've got an audience question. They say, great panel. Congratulations, all of you. You got our first compliment. Are we already seeing an impact of the EU AI Act? Are there elements of the EU AI Act that Canada should look to adopt or avoid? And, we'd be remiss without saying that we're now a couple days after the EU AI Act's official implementation day. And, so Michael, turn it over to you. And there, we might be able to squeeze in a couple thoughts as well on interoperability. You'd mentioned it earlier. And so if you could share that as well.
Sure. So, let's just frame the EU approach. The EU has adopted what we would refer to as horizontal legislation. It's broad scope regulatory requirements vis-a-vis AI, but it also has what I refer to as vertical implementation. The EU approach has been to target very specific uses, some of which are prohibited, some of which are regulated as high risk use cases. And then there's some rules with respect to general purpose AI models, with the most onerous requirements limited to a subset of general purpose AI models, which are viewed as having systemic risk. It's very much a risk-based approach. It focuses on proportionality in terms of the expected response to the risks. And as I said, it's horizontal in its scope, but it's vertically implemented. And anyone who wants to sell into the EU, who has an AI product service, has to be mindful of the EU requirements. You'll need to figure out how to comply. So are there impacts? Absolutely. But the scope of those impacts are narrowly focused on those specific use cases, those specific areas where the EU AI Act applies. I think when you contrast it with Canada's approach as reflected in AIDA, AIDA adopts a much broader scope. It applies more broadly. It is more about regulation of technology rather than specific use cases. And that isn't necessarily how it's described in Ottawa. It's described in Ottawa as being focused on areas where there are risks of harm. But I would say there's more of a veneer of a risk-based approach. And if you really focus on the defined terms and the application of the broad range of different regulatory requirements, It is regulation of the technology. And so, I mean, a couple of examples I think are really important to make this real. I mean, I've just set out a pretty broad statement about Canada having a much more expansive approach to regulation. So how do I back that up? And at Osler, we have done an interoperability comparison as between the EU AI Act and AIDA. There's a publicly available document that sets out our findings. It is pretty clear that there's a dozen or so very critically important distinctions when it comes to, for example, the definition of general purpose system in AIDA. It adopts what I might call a multi-purpose definition. If an AI system can be used for multiple purposes, it's deemed to be general purpose. It makes no reference to a general purpose model. So when we're thinking about ChatGPT, we're thinking about a large language model that can be deployed for many different purposes, but it's fundamentally the model that makes it general purpose. It's not the way in which you could use a system in multiple ways. That's just one example. High impact systems, as is the concept in Canada, as distinct from high risk systems in the US. And two really important distinctions. In Canada, we have these very broad areas of use. For example, the use of an AI system in connection with the delivery of any service from the standpoint of availability, prioritization, or pricing. Whereas in the EU, high risk is defined by reference to the use of AI systems in connection with publicly available services, fundamental rights and services that you might get from a government like healthcare, and a narrow subset of what I'll call private sector uses in terms of, let's say, access to insurance or credit assessments. So the scope is very different. And then additionally, in Europe, there's a overarching requirement that to be high risk, there has to be a significant risk of harm to health, safety, or fundamental rights of individuals, whereas we don't have a corresponding concept in Canada. Now, I mean, I can go on. As I mentioned, there's about a dozen different fundamental distinctions, but I think those are two examples where you can see that definitions, the scope of legislation turns on the definitions that are used. And in Canada, the definitions are frankly just much broader than what we see in the EU Act. And that helps to support my view that the Canadian approach, the net being cast in Canada by AIDA is much broader than the EU AI Act.
Do you guys have any thoughts on that before we move on to the long list of audience questions that are coming in?
Maybe just one more thought. I think the question also talked about, are there elements from the EU AI Act Canada should look to adopt or avoid? And maybe just one thing we've discussed already, but it's worth emphasizing, is that it's still evolving, right? Even the regulation, although it went into effect, is still being implemented through a lot more work, and that's going to shape a lot of these outcomes. And so we're just really at the beginning. If we're looking for models elsewhere on legislation, it's hard to look at something that's fully finished, I guess, is an important point.
Colin?
I think my colleagues have said it well.
Great. So here's a broader question then. Why are we not modernizing the way we regulate? The audience is asking, Canada's behind in adopting the approach of risk-based regulators to better address risk-specifically harm. To better address risk, specifically harm. So why are we not modernizing the way we regulate? Why are we still taking this old-fashioned approach to it, to a new world technology, really?
There's an instinctive response that's based in the stereotypically US approach to regulation. But my question is actually, doesn't this appear like it is a risk-based approach to regulation? It just assumes a much broader interpretation of risk and a broader set of possible complications, and then a greater reliance on interveners, whether it's regulators or whether it's standards holders. So it is in fact a risk-based approach. it's just defined so broadly that it doesn't actually reflect the risks, or it provides an interpretation of the varying levels of risk, as Michael has identified, within the application of the technology.
So what can be done to incentivize the Canadian government to invest in building better regulatory infrastructure to regulate AI across sectors, as you guys have discussed, as opposed to doing, the bare minimum or going as is status quo?
I'd be happy to tackle that one. So, I think it's good to look to other jurisdictions that have adopted different approaches, and other like jurisdictions. So the UK is a good one, I think. The UK has deliberately adopted a pro-innovation approach to AI. Initially, they focused on individual regulators coming up with regulatory models that would ensure within their scope of responsibility, appropriate rules be developed. They then talk about, well, maybe we need a backstop. We need to be able to quickly fill in gaps if regulators don't address the harms that need to be addressed, or if unforeseen harms arise. And even now, more recently, the new Labour government has talked about perhaps regulating frontier models or the most advanced models. And that's a very good approach in my view, because you focus on existing law, existing regulators, subject matter experts addressing risks about new technology within their areas of expertise. They coordinate internationally. You have a light touch approach to regulation. You regulate as you need, but you don't necessarily regulate everything. You have a backstop concept so that if you need to quickly, through rules or reg making, add scope so that there is some additional oversight or requirements, and you have the legislative capacity to do that, regulatory capacity to do that. And then thirdly, if some of the most leading thinkers on AI do point to broader existential risks with respect to the most advanced frontier systems, well, maybe we need some rules or guardrails on those specific systems, whether it be transparency or some type of information sharing, some type of oversight. But let's be very focused and targeted. Let's limit the regulation to what's needed to address that type of more existential risk. And so the EU provides, I think, a useful point of comparison of a pro-innovation approach, which doesn't just say, look, there's no risk, there's nothing to do here, let's bury our heads in the sand, but let's rather look at it in a very targeted way and ensure that the rules and regulatory model that we adopt reflects actual risk and potential for significant harm. So I just want to use that as a comparison.
Great points. We've got, does anybody else have anything else to add to this?
I mean, unfortunately, this is a rearward observation, but if we look at regulatory initiatives from federal departments that have specific industries and sectors that they regulate on a daily basis, the process of developing legislation looks at use cases. It looks at leading technologies and potential applications that relate to their priorities as well as their industrial agenda, and then develop legislation to encompass that environmental scan that they've developed. What we're kind of walking around here in our conversation is that is the sort of conversation that needs to happen before you pass and then apply broad framework legislation around artificial intelligence in Canada. Because unfortunately, part of the nervousness from startups is the regulatory process that's going to come. Is there a structured analysis of the impact upon individual sectors and individual regions that reflects that sort of analysis that you would get from other more focused departments and use cases? Or is it going to rely on the companies themselves who are working with very focused and prioritized resources to both develop the case and then advocate for it within a broader regulatory conversation that takes into account the real harm cases that Michael's been identifying, as well as the specific and then very limited application for very functional uses like Wabi is developing, reflecting that Wabi still has a number of significant issues to resolve, particularly around road safety and reassuring regulators and individual Canadians.
No, that's a fantastic point, and I think you bring a unique perspective on this, given Wabi's sort of position as a startup. So one of the audience is asking, basically, why don't we blow the whole thing up? Why do we need an entire new regulatory regime for AI? Why are professional engineers who are obligated to uphold public welfare not used to ensure responsible AI? Malika, do you have any thoughts?
I mean, look, whether we should, the government has a right, and a responsibility to make sure that the technology is deployed, according to the sort of the traditions and customs in Canada. So as far as blowing the whole thing up, we've been very focused on working with the government to propose some changes to try to clarify a lot of the issues that we've discussed so far. And so that's really been our focus in trying to make sure that we all arrive at a place where we all, I think, agree we want to land. We understand, and I think most of us support the need for legislation and across jurisdictions, right? That's going to help build trust. It's how we do it and how we land in a place that's going to achieve all of the objectives that I think we generally share. Increasing trust across the technology for all the stakeholders, mitigating the risks, and then a range of risks, right? What are today's risks? What are potential future risks? Depending on the use cases, enabling innovation, embedding these concepts of proportionality and interoperability across jurisdictions. Those are the things we want to do. Then, it's really trying to figure out with the process we have, how do we get there?
Excellent. So why don't we wrap up then? The title of today's panel is "How Can Canadian Policymakers Improve the Artificial Intelligence and Data Act?" If you could tell, if let's say the Minister of ICID or the Prime Minister were listening in right now, and I believe the Prime Minister's, I see him on the YouTube. No, I'm kidding. If they were listening in, if you could give them one sentence on how they can improve the Artificial Intelligence Data Act, what would you say?
I think an initial step that's being proposed since the legislation was first tabled was to reflect on the two disparate elements of Bill C-27 and the necessary changes and the long expected changes to PIPEDA in parts 1 and 2, and that they've had a thorough consultation and discussion over many periods of review and in committee, and should be moving forward. But it's obvious to one of the other questions as well that companies that rely on either developing and then deploying foundation models and AI adoption tools, or the companies that are prospective users of that technology, have not had a thorough voice in either the drafting or the deliberation over the legislation, despite it having taken 2 years to move through the first stages of the parliamentary process. So splitting out part 3, the actual part of AIDA, and saying we will either have a pause here and then do some elaborate consultation and have a more detailed analysis before we move forward, before it comes out of the committee, or having committee take on a serious number of additional meetings with a structured approach to understanding the environment and the impact on both innovation and industrial development in Canada is absolutely necessary to have an informed position before moving it forward. Unfortunately, if they continue to move forward as 3 parts of the same legislative package, we're going to be looking at band-aid solutions to try and address concerns and a constant reference to the regulatory process, which unfortunately, regulatory processes can be quite sudden and quite immediate, no matter what the commitment was during the
Yeah. Sorry, just to weigh in real quick, I completely agree that we need more changes than just fixing it in the regs. There are significant changes that need to be addressed in the legislation through some process. Michael.
Yeah, and I mean, there's a very fair criticism that, more consultation is needed, and there needs to be an openness, I believe, to look at first principles, the regulatory objectives, and really ask ourselves if they're being met. And I will just conceptually say that if the government were to go forward with horizontal legislation, which is what AIDA is, I mean, we can ask ourselves, is that the right approach? Is the UK approach better? That's something the government should be asking itself. But if they were to go forward, I think they have to go back to a middle ground, perhaps, between what we call AIDA 1.0, which was the bare framework legislation that was included in the initial draft of C27, and the much more detailed prescriptive version that we see in what we now call AIDA 2.0, reflected through the minister's correspondence with the committee, because they went from having no details to having a very prescriptive approach and losing, in many respects, the opportunity to take a more targeted approach, as we've seen even in the EU. We can now, because at the time that AIDA 2.0 was introduced, the EU had not settled on a number of very core concepts and issues which have now been settled. There can now be a proper assessment of interoperability, and the document that Osler prepared helps in that discussion, I suggest. But there needs to be an openness to really make fundamental change, including to core concepts that set out scope, that are fundamental to ensuring we don't over-regulate or double-regulate or create disincentives to investment in the AI ecosystem or adoption of the AI tools that will enhance the Canadian economy, will help us become more productive, will help us overcome some of the really fundamental challenges that we face as a country and as a world. So I think it's the openness from the government in recognizing that this is really hard. And I'm the first to admit, when I speak with government representatives, like, this is exceptionally difficult. Let's work together to come up with the right outcome for everyone, because I do believe there is a principled approach that can lead to really strong policy reflected in legislation. But we need to have the openness of consultations that allow us to make those types of suggestions that are open for real exploration and acceptance.
Malika?
I guess just some thoughts here, taking a step back and really just sort of figuring out what is the purpose of the legislation. We feel that the debate's been often driven by fears around catastrophic risk. And while we're mindful of that and the possibilities there, our focus as a business is really on our customers' focus, right? Immediate risks that we know that we can manage, bias, privacy, security, how to keep people in the loop for decision making. Sort of that's our focus as a company. And then more broadly, from a legislative point of view, what is the purpose of this legislation? It should be to build trust, to mitigate risk, to enable innovation. All of those concepts are not very well reflected in this legislation. And so how do we, like Michael said, take a step back and sort through how we can arrive at the best place to address a range of opportunities and risks, right? Not just the existential risks.
I think the last question that's come in from the audience is very pertinent. And what role can the AI ecosystem play in moving the needle forward and driving action on legislation? It seems like things have stalled in committee. Colin?
I think they're absolutely right. Hasn't necessarily stalled. I think there's been a very active dialogue, and as Michael hinted, some strange directions taken as a result of the dialogue. But the voice of certainly startups and scale-ups in the AI ecosystem or individual researchers have not been represented thoroughly in the process. And this is a reflection of the role that this industry and this sector needs to reflect in policy development in Canada, because we've long relied on third parties, whether it's associations or others, to speak for us as a collective, because as I've mentioned, we're prioritized on growing our products and developing a business and remaining successful. But it does require some focus, both from our leadership as well as our teams, to inform the discussion and then to provide direction, like Cohere has been doing, to try and point the discussion as well as the legislative proposals in the right way. Unfortunately, it has become something of a black art in terms of being able to understand the process and then communicate within it. And again, that's a question about whether or not other jurisdictions have done this in a more inclusive and collaborative way with both their specialist sectors as well as their industries to inform the legislative process. And I look again to other regulatory departments and the sort of work they've done to build circular dialogues with their regulated entities as well as participants in their industries to inform their analysis as well as their decision making, and then eventually the decision whether or not to move forward with regulatory change, either on an incremental basis or on a wholesale framework basis like we're talking about today.
Yeah, I agree with everything Colin said. And obviously, Lawrence, really appreciate the invitation to participate today. That's helping us share our views more broadly than we have through, some of the regular procedural ways we can through filings and things like that. So really appreciate the opportunity to be here.
Yeah.
Thanks for coming on. Michael, do you have any closing thoughts on how the AI ecosystem can play in moving the needle in, the role the AI ecosystem can play in moving the needle forward on driving forward legislation?
Yeah, I'd like to reiterate Colin's point that it's really tough for companies that are focused on getting their products to market to spend the time and energy that's needed to understand the legislation and the potential impacts. And I think it's really incumbent on government to ensure that the consultations include appropriate representation from across, not just, of course, the AI ecosystem, but across all different groups. And, that's what we missed by going straight to draft legislation. There was no consultation process on this. And I would just think that on legislation that is so fundamentally important, that we really should take the time to get it right. Like, I don't think it's so urgent, and this is where we started the conversation today, that somehow the current state of AI is such that, there's these massive harms that are being caused all around us. I don't think that's what has borne out. And because of that, we should really take stock and say, well, look, do we have time to do that detailed consultation with all stakeholders? And I would say yes. I think it's critically important to get it right, and that's the only way to ensure that we end up with the right balanced approach to a regulatory regime that will impact on all of us.
All right. Well, I think we'll end on that note then. Thank you so much to the panelists for joining me today, Malika, Colin, Michael. Thanks for coming on. Thank you to the audience for coming and listening to us talk about how Canadian policymakers can improve the Artificial Intelligence and Data Act. Really hope that there will be some action moving forward in the fall as Parliament comes back into session, and perhaps there'll be some learnings over the summer. And fingers crossed. So thank you very much.